Baggio, am I saying that right?
Yes, sir. Thank you.
Judge, tell me about Title VI of the Civil Rights Act of 1964.
Title VI, I believe, Senator, is the provision of the Civil Rights Act of 1964, which prohibits the discrimination based on religious preferences, I believe. Oh, I'm sorry. May I strike that? I'm sorry, Senator. I was thinking of Title VII. Apologies. As you're well aware, I'm sure from my record, Senator, in my 18 years as a federal litigator, as well as my 4.5 years on the state court bench, I didn't have the opportunity to litigate issues related to Title VI of the Civil Rights Act. So apologies for the misstatement. And were I to be so fortunate to be confirmed, Senator, I would make sure with no uncertainty that I would be fully fluent in that issue were it to be presented to me on the bench.
Okay.
Hey everyone, welcome back to Hot News Today. If you're new here, I'm diving deep into some of the most gripping moments from the U.S. Senate Judiciary Committee. And today, you need to hear this one. I'm talking about a Senate hearing where Senator John Kennedy puts 3 judicial nominees, Judges Baggio, Brisco, and Lund, in the hot seat. What happens next? It's revealing, awkward, and honestly, a little shocking. Let's get into it.
Judge, is it Brisco?
Brisco.
Brisco,
Senator.
I apologize.
No problem.
Tell me about Title VI of the Civil Rights Act of 19.
Senator, in my 17 years as a member of the bar and 5 years on the bench, I have not had the occasion to address Title VI in my career. However, if I am so fortunate to be confirmed as an Article III judge, I would certainly research and study to be prepared to address that issue, sir.
Judge Lund?
Thank you, Senator Kennedy. I cannot add anything that my panelists have not otherwise add. I can also assure you, though, in the 15 years that I've had the privilege to serve as a judge, that particular provision has not been put before me, but if it were to, I would faithfully review it and appropriately apply all Supreme Court, United States, and Seventh Circuit Court precedent that's put before me.
First up, Senator Kennedy asks a simple question about Title VI of the Civil Rights Act. Judge Baggio goes first and stumbles. Misidentifying a key part of the Civil Rights Act? Not ideal. Then comes Judge Brisco. And Judge Lund echoes the same. This is Title VI, a pillar of American civil rights legislation. Kennedy expected more. Kennedy throws out questions. No notes, no mercy. Standing, Judge Baggio handles it, links it to Article III, a solid save. Kennedy pivots to federal preemption. Things get rocky. Brisco goes with the supremacy clause. But when Kennedy drills down, no clear rule. Federal judges need to know this. Kennedy knows it. Viewers probably know it too. If you're finding this jaw-dropping, hit that subscribe button. I cover real moments from Congress, courtroom battles, and politics. You don't want to miss it. All right, back to it.
Judge Baggio, where does the standing requirement come from?
Senator Kennedy, the standing requirement stems from the cases and controversies provision of Article III.
Okay, thank you for that. Judge Brisco, I got it right this time. Tell me about the law of the case doctrine.
The law of the case doctrine is when a case has been adjudicated, then there cannot be any other collateral claims stemming from the issues that were already litigated.
Okay, thank you for that. Tell me about, Judge Lund, tell me about federal preemption.
Thank you, Senator, for that question. In just using the words in and of themselves, I would assume that that the phrase speaks for itself, that federal law would preempt anything else that would come before it. But again, if I were posed with that particular legal phrase, I would do all that I could to faithfully review what specifically it is about and faithfully apply that definition to whatever the situation was that was posed in front of me.
Kennedy mentions the law of the case doctrine. Judge Brisco explains it means you can't bring up other claims from the same issues, but it's not a confident answer, and in a confirmation hearing, confidence in the law matters. A lot. Let's zoom out. What's Kennedy doing here? He's not just testing them for trivia. He's exposing whether they're ready for the federal bench. These are Article III judges, lifetime appointments. If you can't clearly explain key doctrines, Title VI, federal preemption, it raises a real question. Are you prepared to rule on some of the most complex, high-stakes issues in the country? Kennedy doesn't have to yell, he just asks, and watches the answers fall apart. This hearing was a reminder. Confirmation isn't just about resumes or how long you've been a judge, It's about understanding the law and applying it under pressure. What do you think? Drop your thoughts below. I read every single one. Like, subscribe, and share for more real talk on law, politics, and power. I'll see you in the next one.